Hey guys, probably one of the most bizarre lawsuits that you're going to see. So, well known lock picker McNeely bypasses locks with aluminum can shims. This is a typical technique. The company, Proven Industries Locks, threatens to sue him and also texts his wife. Hilarity ensues, many links and videos. So it is one of these lock picking individuals, and he easily picks. And this lock is not cheap. We're talking about over $100. So a aluminum can shim. It's not as complicated as it sounds. It's just kind of a folded piece of aluminum. Proven then responded with this video stating in comments. The first one shows a full uncut video of him opening a Amazon locker to get the unopened packages and unopened drink cans, cutting a shim and bypassing the lock, all in about 2 minutes. Then apparently Proven contacted McNally's wife and already threatened legal action, so the mad lad did it again. The creme de la creme, a video about yet another type of lock, a puck lock, in which he shims 10 different locks of the same type within 3 minutes. On May 1st, Proven filed a suit in Florida, so they actually did sue him. And surprisingly, they sued him for copyright infringement, defamation, and false advertising, as well as violation of Florida deception and unfair trade practices, tortious interference with business. That's the other one. That's the one that I think I could win a lawsuit against Pokemon for. Unjust enrichment, civil conspiracy, and trade libel under Florida law. Here's the thing again, under Court Listener, a really great website. And here's kind of what he's doing. So the shim is to his right, and that is the lock. And the more they attack the individual, the more he decided to prove how easy it was to break these locks. I think this is a fascinating lawsuit because instead of making a product that could not be tampered with, it may just come down to the judge giving McNally like a can and saying, "Hey, can you open this lock with just the can like you did in the video?" And then like them buying a lock from a local store. You don't want the Proven to provide a lock because it may be different than the ones in the general public. Obviously, you do not want to buy a lock that can be opened with any can of soda this easily. And these videos have gone viral. Part of this is because Proven has sued him, and part of it is because they are very fun videos to watch on loop. And the lock, I do think it takes some type of skill. So I think an ordinary person would struggle. I don't know how long they would be able to find this out. So here's his channel, McNallyOfficial. It's a very large channel. They only do YouTube shorts. And here's him proving or picking the locks. I think it is quite fascinating, this lawsuit, because it has copyright, trademark. It's right. I did not expect copyright and trademark. Typically, when you have a product, you do want people to make videos about it, because even if the videos are bad, you can improve your product. Here, it seems like maybe some of these locks have massive liability. They demanded I apologize. Proven Industry puck lock open with a can. $100 padlock open. They called me out. Now they're suing me. So that one has 12 million views. So you can kind of see that Proven is just gone kind of crazy. That was the original video where I believe they may have copyright strike them or something like that. And they did indeed take him to court. Court will be really easy because if it's defamation, it's the truth, right? Whether or not he can prove that he can open this lock with a can or whatever tools he was using. So this is verifiable complaint for damages and demand for a jury trial. Proven versus Trevor. Plaintiff Proven, blah, 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 Trevor. This is an action for copyright infringement, defamation by implication, false advertising under the Lanham Act. So this is exactly what I do for a living. This is all IP stuff. As an IP lawyer, I am shocked that Proven would sue McNally because all it's going to do is draw more attention to McNally and his YouTube channel, and his and all McNally has done since that point is open more ProvenLocks and shown how easy it is to open. So like the brand, this should be obvious because like if anyone watches YouTube, and obviously Proven does watch YouTube, that's why they're suing him, they would know or come to a conclusion that this is a very common technique. I see the lock picking lawyer, and he uses this technique. One of the first techniques he uses on any new lock that people send to him. Now, in the lock picking lawyer, it seems easy, but it's also that he's trying different methods. Here, I don't know, the Proven Lock, has the lock picking lawyer done a Proven Lock before? Because it seems like they are very, very upset. Plaintiff has complied with all conditions precedent to filing of this action to the extent of Florida. Let me know if I give this video a thumbs up if you want me to continue. This is a very, very long complaint. It is one of the longest complaints in IP I've seen, and I'm not positive. I am not positive that this is going to go too far. I do think it probably will just get hit by summary judgment, and after summary judgment is done, there will be there will be that there won't be any questions as to you cannot sue somebody for copyright infringement when you have a public product and people are reviewing the public product. Even a bad review, it reminds me of the time that this company sued Yelp for a bunch of bad reviews. No, that's the idea, is like if the reviews are real, then you can do a bad review. McNally video was uploaded on YouTube Shorts, Instagram, TikTok, Facebook. The McNally video incorporates an exact copy of experts of the Proven video at its outset and uses it without transformation or commentary except to frame it for ridicule, but that is transformation. Satire is transformation. Shown directly below is the first representative still image of McNally video showing McNally made an exact copy of excerpts, including an exact reproduction of the Proven video. So they went basically frame by frame of this guy's stuff, trying to prove that he was making fun of them. But you can make fun of somebody. This is a company that I think is very butthurt. And as a IP attorney, I don't understand why. Make a better product. If you're so offended that your product may be open this way, make a product that will not be open this way. Make an updated version of it. Refund your customers. Approximately 2 seconds into the McNally video, the footage shifts to a point of view perspective in which the defendant is shown watching the Proven video on a mobile device. The first approximately 16 seconds of McNally's video consists of spliced experts okay, so that's 16 seconds. This is a super bizarre thing to say for a review video, especially a review video that is critical of a company that is producing locks that seems to be quite easy to pick. Just make, is it really that crazy to not make a lock that can be picked this way, or to investigate your team, or have your team look into whether or not this is real and whether or not this person is using this video and clips of the video? I don't think that's copyright infringement. I don't think it's just that's basically satire. That's basically which is protected by in IP law. Satire is not something you can sue for. It's supposed to be making fun of you. Which depicts a first appearance of the shim used by McNally and McNally's lock picking demonstration. Now, yeah, the shim looks kind of unique. It looks like something that has to be figured out. McNally's video at approximately 30-second mark, which depicts a second appearance of a shim used by McNally and McNally. So they're mad. This company is ferociously mad. I've never seen anything like this before, because essentially what you have is you have a customer review, and the customer is always right, because McNally probably purchased these locks, even though, and when you purchase an item, you can do whatever you want with the item, including review it. Defendant failed to disclose that successfully bypassing lock required prior disassembly of the product to examine its internal components, including the position of the plunger. But it doesn't really matter, because as long as everyone now knows, you can use the shim. Video falsely implies a plaintiff's lock product can be easily and trivially bypassed by an unskilled person in a matter of seconds using basic tools without prior. No, he never claimed that. In my opinion, he never claimed that. The infringing video begins with excerpts. So again, they're just so, hey, he showed some clips of the Proven's video about how awesome their lock was, and he mocked them. So mocking somebody is not, it's normally protected under IP law, and as well, it's definitely not copyright. It's definitely not copyright infringement. Satire is one of the most respected things in copyright law. In fact, Voltaire says it best, right? He got this very witty quote about how satire, you should be able to mock different people and items and things, and without that ability, then where are we, right? McNally warranted to TikTok that McNally owned or had rights to all content in McNally's videos as required by TikTok's terms of service. That warranty was false. On Instagram, like the fact that they are actually going to sue for this, and they sued May 1st. Do we have an update on this? If you guys, we have the case number. It's 33 pages. It's literally 33 pages of this stuff, and they get angrier and angrier as it goes on. Anyway, let me know if you guys want to cover this. Give it a like and a comment. If it gets over, let's say, I'm very tempered in my expectations now. If it gets over 60 likes, we'll continue covering this case. There's so much more interesting information. I can tell you this, the lawyer who filed this, I do not believe they understand that they probably won't win this case and is doing it largely for money, or they don't have, and in my opinion, a good grasp of copyright law or defamation law or IP law in general. So I wonder if it's an IP attorney or a litigation attorney specializing in IP. I can easily check that out right now. But I'm just making, this is not the way to write, even if you did want to sue him, which I don't think is advisable. You've done things that, in this thing, that make the case quite weak. Anyway, that's my opinion on it. Let me know what you guys think in the comments below. Bye, guys.